Hello, friends. I welcome you all to this session of Indian Evidence Act. And today, as usual, we will be studying or discussing two sections, Section 144 and Section 145. These two are very important with regard to court works, and in day to day court work, it is of great importance because witnesses are examined and cross examined in the court on these basis. So, just let us first have a bare reading of Section 144 as to what Section 144 Bare Act says. It says evidence as to matters in writing. Like what it says is that if there is something which is written, for example, if he has written something, I love you to this girl, then and it has to be proved, then in that case, suppose the girl says it is to prove it, then in that case, if something is written, then the written should be proved, preferably by written document. And there are two exceptions which are provided to it. One, if he proves that uh, he is entitled to give secondary evidence of it, then in that case he can give um, oral evidence. Or if sit a third person sitting in this behind this tree, he overhears the conversation, then he can give the oral evidence. Basically, this is a derivative from Section 91 of Indian Evidence Act, which lays down as to exclusion of oral by documentary evidence. So, actually, it carries out for the rule makes effective Section 91. Now, let us have a reading of the Bare Act language and then discuss it in detail. Any witness may be asked while under examination whether any contract, grant, or other disposition of property as to which he is giving evidence was not contained in a document. And if he says that it was, or if he is about to make any statement as to contents of any document which, in the opinion of the court, ought to be produced, the adverse party may object to such evidence being given until such document is produced or until facts having been proved which entitles the party who called a witness to give secondary evidence of it. So, basically, what it says is that a witness can be asked, for example, if there is a witness, he can be asked if and if he is going to give any evidence regarding contract, grant of disposition of property, or a written document, then he may be asked whether the document was written, or whether it was a document or not. And if he says that yes, it was a document, then the opposite party may say that the original document to be produced, or he may ask that prove that you are entitled to give the secondary evidence. Now, in this, there is explanation attached to it. A witness may give oral evidence of a statement made by other person about the contents of document if such statements are in themselves relevant fact. So a third party can give oral evidence with regard to the written contents of a document. A illustration is attached which will uh, make it further clear. That question is whether A assaulted B. So question here is that whether A has assaulted B. Now C, who comes as a witness, disposes that he heard A say to B, that A was saying to D, that B wrote a letter accusing me of theft and I will take revenge on him. That B wrote a letter that A is involved in a theft, and um, A is saying to D that I will take revenge because B has written such letter. Now, this letter is actually what B did is contained in a document as claimed by C. But as C has not received that letter or C is not a party to that letter, C has just overheard A saying D about the letter. Then in that case, C can dispose about it. And the matter is relevant because it gives the motive of the assault which is claimed. This statement is relevant as showing A's motive for assault, and evidence may be given of it, though no other evidence is given about the letter. Now, let us see that what are the other fine points. A witness may give oral evidence of a statement made by other person about the contents of document if such a statement in themselves are relevant. As we have just seen that a third party can give um, evidence to it if that is relevant, as we have seen in this illustration. Then another is, as we have seen, that it may be noted that section 144 lays down a rule for purpose of carrying out the provisions of section 91 as to exclusion of oral by documentary evidence. That basically section 144, what it does is that it brings into force section 91, that is, where there is a documentary evidence, their oral evidence will be excluded. So that is what is section 144, that if a matter is in written, then it has to be proved by that document. There are only two exceptions where the party is entitled to give secondary evidence or whether it is overheard by the third person. Next is section 145. This is very important because it deals with the cross examination of the witnesses. Now, what it says is that if there is a written document or written statement given by a witness earlier, then he can be cross examined. Suppose he has given this document to the police officer, uh, this written document to the police officer, or the police A has said it and police officer has reduced it into writing. Then, suppose he is the witness about it, then he can be cross examined on this basis. First point. And while cross examination, it is not necessary for the cross examiner to show him this document. That is one point. Second, that he can be contradicted on this basis. That cross examination can be held for contradiction of what he is saying now and what he has said earlier, which is put in written by himself or by the police officer. But when it is used for simple cross examination, the advocate who is cross examining need not show him the document. But when it is used for cross examination, and in that cross examination, the aim is to contradict the witness, then his attention must be drawn to that part. So, this is what is section 145, and it has to be read with section 162 of CRPC, which says that whenever a statement given by a witness is reduced in writing, then it can be used for cross examination of the witness. Now, what Beer Act says is that cross examination as to previous statement in writing. A witness may be cross examined as to previous statement made by him in writing or reduced into writing. So, whether he has himself written it or it was written by someone else, and relevant to the matter in question. The fact should be relevant to the matter in question. In simple cross examination, without such writing being shown to him or being proved. So, for simple cross examination, there is no requirement to prove it or to show him. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are used for the purpose of contradicting him. So, if the idea is to contradict him, then his attention must be drawn to those parts. Now, let us see it in detail. So, section 145 provides for two things. One is cross examination, and another is cross examination with contradiction of witness. And the basis is the previous writing made by the witness or reduced into writing by the prosecution. So, a witness may be cross examined as to previous written statements which are relevant to him without showing him such a statement. So, in simple cross examination, there is no need to show him. But if the intention is to contradict him, then his attention must be drawn to those parts which will be used for contradicting. Now, what is the object of it? Why this provision is made? Because it is one of the method to impeach the credit of witness, to test his memory, to contradict him by his previous written statements, so that one of the way in which it can be found out that whether he is speaking true or false is by cross examination with the previous written statement. Now, one very important point is that the statement not only includes what is expressly stated therein, but also what is necessarily implied therefrom. So, in this way, omissions in a statement may amount to contradiction. Now, this is important thing. Let us understand it. So, suppose not only what he says, but what he omits to say or omits during one statement is also important. For example, now A makes a statement. What he gives his in his written statement, he says that he saw B killing C to death. In that, he says that in his written statement or in a statement which he himself gave to police in writing or which was reduced to writing, he says that he saw B killing C. Now, in the court, what he says is that before the court or in the court, he says that B and D killed C. Now, here in this written statement, he omitted the name of D. But in his oral statement, which he is giving in the court, he is naming D. Now, this is a type of contradiction because in the written statement, he had missed an important or he has omitted an important aspect of the case. So, this would contradict the present statement that he saw B and D stabbing C. So not only what was written, but if it is material omissions, then that would also be relevant. Now, in Mohanlal versus State, it was uh, stated the object that why it can be used. So, previous statement of a party can be used only to contradict him, and not to contradict other witnesses. So, suppose this written statement was given by A and another witness Y also comes, but Y has not given this written statement, then this written statement cannot be used to contradict Y. It can only be used to contradict that witness who has given the written statement. Section 145 is not attracted when a statement made by one witness is contradicted by another witness. So, if there is any contradiction between A and Y, who are witness of the same party, then that case this will not be relevant. In Nanko Singh versus State, what was held is that evidence recorded in criminal proceedings can be used to contradict under section 145. As we all know that a statement given before police is not relevant. This is as per section 25, that confessions made to the police officer or a statement given to the police officer is not relevant. Now, Section 162 that of CRPC also says that the statement which is given before a police officer during an investigation are not cannot be proved in court. But this is one exception which is mentioned in section 162 also, that statement given before police can be used to contradict the witness. The statement in FIR made by witness can be used to contradict him. Section 162 CRPC imposes a bar on use of any statement made by any person to police officer in course of investigation. So if any person has given any statement to police officer and police officer has reduced it into writing, then it cannot be used to prove. But this exception is that it can be used for contradicting the same witness, for contradicting A, if he says something else in the court of law. So that is all section 145, which says that previous written statement can be used for cross examination as well as for contradiction. But when contradiction is being done, then in that case his attention must be drawn to those parts with which it is intended to contradict him. So that's all with section 144, which deals with evidence as to matter in writing should be proved by writing, and section 145, which says that previous written statement can be used to cross examination and contradiction of witness. That's all. Thank you, friends.